wrap it up?
Yeah, I think so. Hello, my name is Brian L. Jackson. I'm a Tulsa attorney, and today we've been talking about self-defense related issues, and specifically the carrying of weapons. Today, I want to talk about the use of force, both deadly and non-deadly force, and there's different rules that apply in both cases. Now, the first thing that often gets discussed in the context of self-defense is whether or not there's a duty to retreat, and state laws vary on this topic. Now, in Oklahoma, we are not a duty to retreat state. We are what's called a stand your ground state. You are not obliged to retreat if you're confronted with force, even deadly force, as long as you weren't the one that provoked it. You're not obliged to retreat. You can respond with a proportionate amount of force. Now, that's the law. I will say, as a practical matter, generally speaking, if you can get away safely, retreat is probably your better option for a couple of reasons, some of which are legal and some of which are more or less safety. But a big thing to keep in mind is just because you have a defense in criminal court does not mean you won't get arrested, does not mean you won't go to court, and does not mean you won't go to trial where you'll have to assert that defense. So if you are someone who carries a weapon on the regular, and you're thinking, well, what's my game plan if I actually ever have to use this weapon, which is something I would sincerely hope for those of you listening who are in the habit of carrying weapons that you've thought this out enough to have a plan in mind of what you're going to do with a given scenario. And that plan should include, do I run or do I fight? And under what circumstances do I decide one way or the other? So that's something to think about. There is not a duty to retreat in public. Although, again, my personal opinion, both as a legal practitioner and as someone who does carry weapons, is that if you can get away safely, you're not putting yourself in danger and you're not putting a loved one in danger by running, run. You'll save yourself a lot of headache and potential danger by not confronting this person. But if you can't run, then yes, you do not have an obligation to run, or if you don't want to run, you don't have to run. We also have what's called castle doctrine inside your home, your place of business, and interestingly enough, your automobile. Now, what castle doctrine is it creates a legal presumption that if someone breaks into your castle, that is your home, your place of business, your car, while it is occupied by you, then if you resort to deadly force into self-defense, it's presumptively reasonable. Now, a presumption doesn't mean that it's decisive, but there's a strong inference that you acted reasonably. But you should be aware that if, for example, you hear a noise in the night, you get up to see somebody's little punk-ass teenager climbing out your back window with your television, no, you can't shoot them in the back. By the same token, you wake up from a noise in the night and they're standing over you, you laying down in bed with a big ass knife. Yes, you could shoot that person, and you would probably not. You shouldn't be convicted of a crime. But again, going back to what I'm saying, it doesn't mean you don't get arrested. You may not, but you could. So it's something to be aware of. So that's duty to retreat. Now, the other thing I want to talk about is the key component of any self-defense issue is reasonableness. And the thing about reasonableness in law is reasonableness is one of those things that's kind of a thorny issue because it's not a hard and fast black and white, this is reasonable, this is not in most cases. A lot of things sit in a gray area. So you get situations, perfect example is the shooting that made the news a couple of years ago out of Muskogee, where you had a bunch of teenagers broke into a house and the guy happened to be armed with an AR-15 rifle and they got shot. So when we talk about reasonableness, there are people who to this day will argue with a straight face that he was not reasonable to resort to a rifle against teenagers armed with blades. And here's the thing you got to think about with this, when in the context of reasonableness. If it does go to jury trial, you're talking about asking 12 citizens of that county whether they think you were reasonable or not. But reasonableness typically is like this. If a reasonable person, which is your average person, would think under those circumstances their life and safety were in danger, then you're probably okay if you resorted to deadly force. So, if obviously you have to think that in good faith, you have to have not provoked it, but that's kind of where you're at, and that's kind of how to think about it. Now, what that actually looks like in practice, well, somebody typically the obvious examples are if the person's pulled a weapon on you, if the person is behaving aggressively with the weapon. Another situation I've seen in some of my cases is what's called disparity of force. So this is like, for example, if you have like a 200-pound male attack like a 110-pound female, there's a substantial disparity in force, and even if he has no weapon, that could still be construed as deadly force. She could be privileged to use deadly force in response. So that's kind of how to think about reasonableness. And then two, it's like the holistic circumstances. So like, you again, to use the house burglar example, if they come into your bedroom and you wake up to see them there, that's a different situation than like if that same person is sneaking out your back door and when you walk in and they're running off with your property. One of those situations was pretty clear cut. It would be reasonable to employ deadly force. The other one, it would be unreasonable to employ deadly force. What's another good example? If somebody is, well, like if a 10-year-old child pulls a paring knife on you, you might have an issue if you try to pull a gun and shoot them. Yes, a paring knife could be considered a lethal weapon under some circumstances. Yes, you could certainly get hurt. But if you're an adult dealing with most 10-year-old children, you could probably physically overpower them with non-deadly force without like serious peril to your life. So yeah, that's where you're going to have a problem if you pull your gun and shoot them. Or if it's like, you're standing at one end of your block and somebody that like 4 houses down starts yelling and cussing at you, you can't shoot that person, even if they're behaving extremely aggressively. Why? Because that is just not reasonable. That's the reasonable analysis. Some other things to think about. What is the difference between deadly force and non-deadly force? Well, deadly force is that force which could be reasonably expected to cause like serious bodily impairment, like in other words, serious injury or death. Shooting, stabbing, running somebody over with a car, major disparity in force between two people who are unarmed. Like Brock Lesnar decides to go stomp a mud hole in a 110-pound teenager. That's an example of deadly force. A lot of different kind of implements at the end of the day boil down to deadly force. So things like if somebody comes at you with a hammer, a baseball bat, screwdriver, rolling pin, just to get a little bit more creative there. Any of those could be construed as deadly force. Non-deadly force would be like most of the time a punch in the face. That's the non-deadly force.
A shove. Strangulation.
That's deadly force.
Okay.
Probably a kick in the nether regions, although painful, would be considered non-deadly force.
How about a blow to the neck?
That could be considered deadly force, especially if it's applied with a hard blow to to the neck. Okay. But a punch in the face probably is not deadly force unless you were talking about a major disparity in force. An adult punching a small child in the face would be considered deadly force, probably. But an adult punching another adult is probably not. A slap is not usually deadly force. Other things they're technically force that you wouldn't think about. If you grab somebody, like say somebody's acting crazy and you bear hug them, that's force. Now it's generally non-deadly force, but that is force. Tripping a thief who's running off with your property, that's force. Non-deadly force, but it is force. Also, another thing to consider is threats of force, because the law in Oklahoma doesn't distinguish. So if you pull a gun on somebody, even if you don't shoot it at them, that is still considered deadly force, because what is the message of pulling a gun? You're threatening to shoot the person. So it's threat of deadly force. So to do that, you have to be in reasonable fear for your life, or else you're going to get a charge pointing a fire, feloniously pointing a firearm. Or assault with a deadly weapon. Or in the case of a blade, it would usually be assault with a deadly or the dangerous instrument. But same idea is, you have to have some articulable reason why you felt the need to do that. And in terms of non-deadly force, if you get up in someone's face and like wind up like you're about to throw a punch, that's an assault. And if you don't have a good reason for it, you just committed a criminal assault. Now, it's a far less serious crime than something involving a gun, but it is a criminal assault. So again, the idea is it has to be reasonable. It has to be proportionate. I mentioned several times about you can't be the instigator. So what does that mean? Well, there are certain behaviors that are considered privileged behaviors. And some of them are things you would find quite surprising. There's actually a case on the books. It's a constitutional case where you do in fact have the constitutional right to flip off the cops. So if it's generally speaking, if you're in a place you have a right to be, if you're engaging in privileged legally privileged behavior, like for example free speech, and it's not like fighting words, then yes, you're not doing anything that would vitiate that right of self-defense. On the other hand, if you and somebody else, like the classic scenario I can envision here is you have two guys in the bar both trying to flirt with the same woman, and they decide we're going to settle this the old schoolyard way and start butting chests, and each one's daring the other one to throw a punch. Neither of them would be privileged in self-defense if they end up in a fight, because they are both guilty of instigating. Now, if one of them should withdraw, like for example, guy A gets hit real hard and decides, I don't want to fight anymore, and indicates his desire to withdraw from the fight, whereas guy B decides he's going to stomp a mud hole in that dude and continues to be aggressive, then guy A may regain his privilege of self-defense. But if he was actively involved in instigating that fight, he has no privilege of self-defense. Another scenario where you have no privilege of self-defense is if you are actively engaged in a crime, especially felonies. So, for example, the burglar who breaks into the house, even if the owner is unreasonably employing deadly force, is probably not privileged to respond to the owner with deadly force,
Right.
because you're committing a felony just being there. So, or another example is drug dealers. A lot of drug dealers carry weapons. Well, if they shoot somebody to protect their drugs or their cash, they don't have a self-defense privilege.
No.
It doesn't matter if that person pulled a gun on them and tried to rob their ass,
Right.
because they're committing a crime. So that's another situation where your privilege of self-defense is vitiated. Now, it would be an interesting question if you were talking about a situation where you had a firearm someplace you weren't supposed to have a firearm, and you employed it in self-defense. But I suspect that if you were committing a crime by possessing that firearm, you're probably going to get jacked up on the self-defense. You may not have a privilege of self-defense under those circumstances. Although even if you do, you're still going to get whacked for having that gun. But I think that would be a question. Like, you carry a gun into the courthouse when you're not supposed to have one, and somebody attacks you in the courthouse and you shoot them, assuming it was otherwise a right to shoot. They legitimately threaten you with deadly force, and you had every reason to fear for your safety. You draw your gun and fire. You were breaking the law by having that gun. So it is arguable that maybe you don't have that privilege. If you're DUI, same problem. Like, you're drunk off your ass and you're armed, and somebody comes up to you and starts behaving aggressively, you may or may not have that privilege if you were drunk, because by being drunk and having that gun, you're committing a crime.
Right.
So the bottom line is those are situations where you may not have that privilege. one distinction between deadly and non-deadly force too. Non-deadly force can be employed in protection of property. So, for example, you catch somebody trying to pickpocket your wallet, you turn around and throw a haymaker and knock them on their ass. You're probably fine. On the other hand, same scenario, but you pull out your butterfly knife and stick it between their ribs, you're probably going to go to prison for a very long time. Because one's deadly force and one's not. Also, when you're talking defense of others, the rules are different. You can use non-deadly force to defend other people. Now, you can also use deadly force to defend other people, but only in very specific situations, because you have to have certain relationships with that person if you're employing deadly force. Typically, it's like a child, a spouse. Interestingly enough, an employee-employer relationship qualifies. If you have some kind of like affirmative duty to that person to protect their physical safety, then you could employ deadly force. Otherwise, if you employ deadly force on behalf of a stranger, then you stand in their shoes as to whether or not they had a deadly force privilege. So there are stories about cases involving folks who get arrested by undercover cops. Some good Samaritan sees this, thinking that it's a kidnapping, which would normally justify the use of deadly force. They get involved, and lo and behold, it was a cop. Well, they're going to go to prison for a major felony, because they stand in the shoes of that person. So the takeaway from this is, if you don't know what's going on in that situation, don't insert yourself into it with your gun. You're not armed to go be a part-time cop. You're not armed to be a soldier. You're armed because you are concerned for your own safety, or expanding that, your own safety and that of your immediate family, your spouse, your children. Beyond that, if something's going on and it doesn't concern you, you want to be a good citizen, call the cops. Don't get involved, because you don't know. And you take you take your life in your hands, because they might turn around and shoot you. And two, you take your freedom in your hands if you're wrong and you don't know. So the golden rule in that scenario is, if it doesn't concern you, they're not threatening you, they're not bothering you, you go somewhere safe or out of sight and you call 911 and you stay the hell out of it, because you could get jammed up really, really bad that way. So those are some things to be aware of with the use of deadly, non-deadly force. If you have any questions about that, or you have a specific situation you want advice on, I'm always happy to talk about these things. This is an area of law that really fascinates me. I can be reached at 717-460-4881, and I'd be happy to give you an hour to take an hour of my time to talk to you about these issues. Thanks.